Mr. Michael Addo for giving us our first news bulletin of this morning. It's time for us to enter our legal discussion of the day, we call the Chamber. Time for us to go into the chamber, and this morning we're talking about duress. Now, in the legal world, under duress is a term that's been thrown about very, very often. Today we're going to find out exactly what it means and how it may have impact on your case. Joining us in the studio this morning, I have Nana Kwesi Iwa. He is a legal practitioner, will be educating us more in duress. Good morning, sir. How are you?
Good morning.
Welcome to the show, as usual. All right. First off, let's get the definition. What is termed as duress?
Duress may be defined as an act, conduct, situation, event, circumstance which inhibits free will or volition, such that if you have to make a decision and there's some act or conduct on the part of another person which induces you to make a decision in a way that you wouldn't have made it normally.
Right.
That amounts to duress. So, for instance, it could be an example could be the use of force. For if someone has a gun pointed at you to sign a contract, that would be duress, or the threat of use of force. That could amount.
All right. So, in circumstances where we've been told, for instance, that maybe a witness statement was taken under duress, or maybe evidence was, captured under duress, how would this have impact on the case itself?
First of all, the first thing that needs to be considered will be admissibility. Now, if you are defense attorney and you are challenging a witness statement or a confession statement or anything on the basis of duress, you need to prove that this statement was gotten or this confession was gotten out of duress. That is either by force or the threat of force by our investigative authorities. On that basis, you may push for the statement or the evidence not to be admitted. However, if you push and the judge feels that because it is relevant, it may be relevant, and that per our laws, it doesn't matter how the evidence is obtained, you may make a statement or two or a comment as to the weight that should be attached to such an evidence.
And so once that's been established, and let's just say that the judge has accepted this form of evidence, does that mean then the term no longer exists for that particular form of evidence or statement that is not taken under duress?
Well, yes, it does. In fact, particularly on confession statements, where an accused person admits to the commission of an offense or a crime. In criminal proceedings, by law, under the Evidence Act, that statement ought to have been made voluntarily. Now, if the police arrest you, they take a caution statement from you. Then they take a charge statement after they've charged you with whatever offense. Now, in the statement that you are given, sometimes you write it yourself, sometimes they ask you questions, and then as you answer, they put it down. Under normal circumstances, what is supposed to happen is that after they've written it, they ought to read it out to you and explain it to you. And then it needs to be certified that the statement was read to you and explained to you, and that you made the statement on your own free will. You are not forced to make it. And in that circumstance, it can be used against you in court. Indeed, as an accused person, you have the right to remain silent.
Now we've mentioned force is a major factor when it comes to duress. Is it just physical force, or literally all terms of force? We're talking all psychological, emotional.
Yes, all terms of force, even the threat of force. So I may not necessarily, or the investigative authority or whatever who is exerting the duress may not necessarily hit you or point a gun at you, but may simply threaten you that I will do this if you don't do that.
Okay. Now we have serious situations in our country whereby corruption and bribery have taken, center stage. Is a bribe a form of duress?
I wouldn't classify bribe as a form of duress.
Okay. Will that be more like coercion?
It wouldn't be coercion.
It's just simply a bribe.
It's just simply a bribe as it is.
Okay. And in regards to, if there are parties involved which may know other information, i.e. about this particular case, is it possible for more than one or two people to be under the same form of duress in order to achieve a common goal?
Yes, that is true. Duress can be exerted in any way. It can be direct, it can be indirect. So I could decide that instead of exerting the force or the threat of force on you directly, I could go after your wife or your child or your relative through that way, that hey, if you don't do what I'm asking you to do, this is what is going to happen to this relative of yours. Okay,
let's turn the tables now. Let's find out. So if you are found to have been putting somebody under duress, what are the consequences?
Well, in the first place, the first offense that comes to mind will be the obstruction of justice.
Okay.
So if in the course of proceedings, a case in court, and you are found to have exerted some force or duress on another person, you could be cited for obstruction of justice. That is one. The other is that in civil relations, let's say in agreement, contract, what have you, it has there's a likelihood that whatever agreement that has been reached between the two of you would be set aside on the basis of that. But then the effect of duress in such agreement makes the agreement voidable.
Okay.
So you need to take steps to set aside the agreement.
Right.
You can't just sit in your room or your house and say that I was under duress, and so I won't enforce, or I won't perform my obligations under this agreement. If you feel that you are under duress, take the steps.
So you always have to actually prove the duress.
Exactly. And it is you who alleges who must prove.
Okay. Right. But then, like you said, so if it is found out, contract null and void. That's it.
Yes, you can take steps, and then when you prove your case before court, the court will set aside the contract.
Null and void. Okay. Now, what about the actual, in a police case, let's just say, for instance, evidence or witness statement was taken under duress. The case has now been thrown out. What would happen to that person who took that evidence, apart from obstruction of justice? Are there any further sanctions that could be taken against them?
Well, yes.
Could the opposite person sue?
Exactly, you can't sue. First of all, you determine what kind of duress it is. If it was as a result of violence, the person being beaten, you can sue the person for assault or battery. Then again, there are avenues within the police administration which you can also exploit, such as the PIPs. You can make a report to PIPs that this is the conduct of this police officer when he was taking evidence or my witness statement. This is what he subjected me to, and PIPs will take that up.
All right. So in general, then, it is a very it is an illegality. It is an offence.
Yes.
Is it possible to be jailed for a form of duress?
Well, if it amounts to obstruction of justice, it's a criminal offence, and you can be jailed for that.
What would be the sentence for something like that?
I do not have that readily, but it is a criminal offence.
You can serve jail time.
Exactly, for that.
All right. I want to thank you so much for coming in this morning. Hopefully, the people out there have understood the duress a little bit more, and hopefully they're not under duress to watch our show as well. Thank you so much for joining us this morning. There's been Nana Akwesi, he's a legal practitioner and a very good friend of ours here on NewsDay.